Yes.
My lord, one matter is required to be mentioned by you. It's regarding the inclusion of the list.
Regarding?
Inclusion the list. It is the SAT 80 of 2019. It is pending law.
Okay, hearing matters, just wait for this week. Mention next week. Inclusion for hearing. Application, yes.
My lord, application in connection.
Yes, any application, please give. Application. Please. Appeals for non-prosecution, okay. To be mentioned.
My lord, may I be allowed to mention, this is one matter Rashid heard on 8th December 2025
Yes.
and directed the matter to be posted on 6th January 2025, that is today.
Yes.
And interim order was extended till 16th January. But inadvertently, the order records the matter to appear on 6th December.
So let it appear as to be mentioned for correction.
My lord, may I permit to mention, my lord? On second, my lord heard the matter, my lord directed the matter to be listed today. Again, my lord, the matter is not listed. My lord, Mr. Srivastava,
Yes, give it.
my lord, kindly appear tomorrow, my lord.
It is under what heading? Application?
Application, my lord. No, আমার application না ওটা application
An application, yes, give the slip.
ওটা আমি other side আর কি
This is my
দিন।
application.
Are you appearing in person?
Yes. This is my application in person for
For?
urgent listing and hearing. It is already listed in today's case.
Okay.
To be in the to be mentioned section.
No, it is appearing in the list. Or it has to be.
Yes. It is appearing.
So let it be called on. So let it be called on. There is no name necessary for mentioning.
Okay.
Let it be called on.
my lord, it would be appear, my lord, tomorrow, my lord, because
Yes, if the record is here, it will appear
yes,
tomorrow.
my lord, supposed to appear tomorrow,
Record
today.
Inform the other side.
Yes.
It's true. Let it appear under the heading to be mentioned, but filing of paper book is required.
Yes.
My lord, I'm saying let this matter appear under the heading to be mentioned. My lord, the extension of interim order from the list and determination of Honorable Justice Choitali Chatterjee Das, my lord. My lord has
Extension of interim
yes,
order.
my lord. My lord, Honorable Justice is not sitting till 16th.
Yes, give the slip.
To be mentioned, let it appear, my lord. I have given notice.
Yes.
To be mentioned.
Correction last.
Correction, yes, give the slip.
হ্যাঁ না এনআই অ্যাক্ট এই জজ সাহেবের ডিটারমিনেশন আছে কারণ 23 সাল অবধি ওরম ইয়েই করছে হ্যাঁ ওখান থেকে ওনারই অর্ডার আছে
Yes.
Same matter.
To be mentioned. Correction.
এক্সটেনশন অফ ইন্ডিম অর্ডার
Slip.
My lord, I'm applying for the respondent number 2. The appellant is not present. I am for
68,
the
you are for the respondent.
my lord, I am for the claimant respondent.
No, item 68.
Yes, my lord. It is 10:30 fixed matter.
Okay, let it be passed over. Let me call the to be mentioned matters. Thereafter, this matter will be called on.
Grateful, my lord. Okay.
Item number 2 in this matter, my lord, Mr. Kishanu Bonik is respondent on behalf of the. He's
Is it
praying for
correction?
Passover, short Passover.
Is it okay? Pass over.
Passover.
এটাতে টাইম করবে
Yes, next.
I for the appeal not Mr. Soibal. Three.
You are for?
আমি বলছি দাঁড়িয়ে আমি বললাম I for the appeal not.
Yes, you are.
I am for the insurance company.
Any correction is to be made in this order.
Filing lot, let the matter be hard.
Yes, record an order.
Any date. Fixed any date, my lord.
Learned advocates for the parties are present. As the appeal is ready for hearing and the paper books filed, let this matter appear for hearing on 19/1/2026.
My lord.
For my lord, I am for the appellant petitioner.
Yes.
My lord, I have filed an application, my lord, for extension of interim order because, my lord, it was expired.
What is this? Can 4?
My lord, can 6.
Can 6?
Can 6, my lord.
What is this can 4 for?
My lord, that is, my lord, for adducing the additional evidence, if I, my lord, in the second appeal.
The other side
My
is
lord,
not.
other side never appeared.
Matter is ready for hearing. You are for the appellant.
I am for the appellant. Matter is ready for hearing. Paper book also submitted, my lord. If your lordship be kind to come to the last order, which
No,
is
paper books are ready.
yes, yes.
Paper books file. Yes,
Fine.
record an order.
My lord,
Learned advocates for the appellant is present. None appears for the respondents. As the matter is ready for hearing and the paper books filed, let the matter appear for hearing on
my lord,
19/1/2026. The interim order granted earlier stands extended for a period of 8 weeks or till further orders, whichever is earlier.
grateful, my lord.
Let the learned advocate for the appellant is requested to intimate the opposite party.
My lord, I shall, my lord. Grateful.
Number 5 to 8.
I for the claimant respondent, your lordship. Your lordship, this matter was appearing in yesterday. This should kindly remember. Only the appeal was not tagged. Your lordship, the matter is ready. Paperwork have been filed. Your lordship, can you take it tomorrow? Your lordship, this is old matter. Your lordship, pending for long.
Old matters 22. Yes, record an order. Learned advocates for the parties are present. As the matter is ready for hearing and the paper books have been filed, let this matter appear for hearing on 15/1/2026. 15.
Deeply obliged.
Grateful to my lord.
Number 9.
Yes, not today.
My lord, item 11-12, it is appearing at our instance, my lord. My lord, the interim order is still today. We had mentioned the matter, my lord, for extension. My lord may extend the interim order and fix a date for hearing. My lord, there's a second appeal, my lord, which is a.
You are for?
I'm for the petitioner appellant.
You are for the petitioner appellant?
Yes, yes, my lord. The interim order was passed by the Honorable Division Bench, my lord. And thereafter, my lord, it was admitted because it is appealed from the RERA Appellate Authority order. And then thereafter,
Is it to be heard by the single bench?
Yes. My lord has in the last occasion extended the interim order by an order of 25th of November 2025.
No, what is this application? Can 1?
Can is a stay application.
And can 2?
My lord, can 2, my lord, is the yes. For that was the respondent's application for vacating.
So paper books have been filed.
Paper books filed.
Paper books have been filed, but no formal order has been.
There has been no formal order direction, but then we have
But file the paper books.
Yes, we'll file the paper books.
Yes, record an order. The learned advocate for the
petitioner,
appellant petitioner and the respondent, Angshuman Bhattacharya, appearing in person are present. As the let the paper books be filed on or before 19/1/2026.
It may be, my lord, the 1 week more than 19th of January 19th.
Okay.
By 30th.
Okay, 27.
By 27.
1/2026. Copy be served. Let this matter appear for hearing on 27/1/2026. The interim order granted earlier stands extended for a period of 5 weeks or till further orders, whichever is earlier.
Grateful, my lord, deeply obliged.
My lord, what the date or date
27/1.
Date for hearing is not fixed.
No, 27/1 is the date fixed for hearing.
27/1 is the
Yes,
date fixed
date
for
fixed
hearing.
Yes. You serve
Grateful.
copy of the
Yes,
paper.
will be prepared a paper book. Now, my lord has given a directive. We'll file. Grateful.
Lordship, I appear for the petitioner. Mr. Supratim Laha was arguing in this matter, Lordship. I'm praying for not today because he could not attend the court due to his personal reasons, Lordship.
So I keep it on Friday.
As your lordship pleases. Lordship,
Matter
the
be-
interim order is still 15th January.
Okay, I'm making it just not today.
Yes, your lordship. Grateful.
Hello, item number 13, I am appearing before respondent and claimant. My lord, paper book is not ready, my lord.
Item 14.
14, my lord.
You are for the respondent claimant.
Yes, my lord.
So paper books have not yet been filed. Yes, record an
Some
order.
report, my lord.
Record an order. Learned advocate for the respondent is present. As the paper books have not yet been filed, let the same be filed on or before 20th January 2026. Let this matter appear on 20th January 2026 under the same heading.
Item 15, my lord. Yes.
Item 15, you are for the appellant.
Appellant, my lord. All formalities has been completed, my lord. Ready for hearing. My lord, very short question involved, my lord. Future prospect at the time of my lord calculating the compensation amount, future prospect not added, my lord.
So this which year? 2025 matter.
Yes, my lord.
Claim case of which year?
Claim case of claim. Appeal is 2014.
2025.
2025, my lord, FMA number has been allotted. My lord, appeal has been filed 2014.
Oh,
And claim case,
2014.
yes. Claim case is, my lord, 2011.
Acha, record an order. Learned advocates. Learned advocates for the parties are present. As the paper books have been filed and the matter is ready for hearing, let this matter appear for hearing on 19/1/2026 within first 10 matters.
My lord. 16, my lord, same. Mr. Singh is
I'm for
appearing.
the appellant, my lord.
Ready for hearing.
So
No,
this is also
appellant.
filed when?
I'm for the respondent.
No, which year appeal is filed?
Appeal has been filed, my lord, on 23.
23. Okay, all formalities complete.
All formalities.
Record an order. Learned advocates for the parties are present. As the matter is ready for hearing and the paper books filed, let this matter appear for hearing on 20th January 2026.
My lord, 28th.
20th, 20.
20.
My lord, 17, I am for the claimant respondent, and Mrs.
Can 3 is whose application?
No, there is no application, lordship.
17.
17.
Yes, can 3.
My lord, Mrs. Paul is for
আমি তো
the.
বলেই দিচ্ছি, Mrs. Paul is appearing for the appellant, lordship. I am for the respondent. Matter as lordship was on our mentioning, lordship fix the matter for to be mentioned only on the ground. The record lying in the department is required to be tagged
Okay,
with
record an
that is
order.
the order.
Learned advocates for the parties are present. Let the trial court's records be put up with this file. Let this matter appear on 13/1/2026 under the same heading.
Yes, lordship. And
Paper books are not yet filed.
paper book file, lordship kindly also directed the department director to tag the court also.
No, that the cross subject. আচ্ছা লিখেছেন বলুন কি লিখলেন?
The list দিয়ে দেবেন।
Along with this file, along with this record. Acha, let the cross objection being COT
96 of 2025.
96 of 2025 be
Tagged with the
put up along with this appeal on 15/1/2026.
2026. Only the record is lying with the lawsuits department.
Yes, I've directed. That's 18. Actually তো ডিটারমিনেশন নেই এখন তো আর অন্য বেঞ্চে যেতে হবে আর কি।
আরে ইয়ে
দেখি কি দিয়েছে। অ্যাকচুয়ালি এটা তো আবার ইয়ে করা যাবে না, এই বেঞ্চে কোনো অর্ডার পাস করা যাবে না। হ্যাঁ, নট টুডে করে না, নামানো তো যাবে না, অর্ডার পাস করতে হবে প্রায় রেগুলার ইয়ে মানে অ্যাপ্রোপ্রিয়েট বেঞ্চে। ইয়েস, রেকর্ড অ্যান অর্ডার। The record is put up with the report of the learned mediator. As this bench does not have determination to pass necessary orders in this criminal revision matters, let this matter be placed before the regular bench along with the report of the mediator.
In this matter, Lordship, I am appearing for the appellant, Lordship.
Paper books are ready.
Paper book has not been filed, Lordship, till now.
So let it be filed.
Lordship, what happened, Lordship? Special messenger cost has been deposited.
Trial court records have come.
If I don't know, Lordship, the healthcare has come or not, Lordship.
Ache. Yes, record an order.
Lordship, kindly send this same
To the department, my lord.
No, trial court records have come.
But Lordship,
Okay, for obtaining copies.
Lordship.
Yes, learned advocate for the appellant is present. As the trial court records have come, let the paper books be filed on or before. Let a paper book be filed within 4 weeks. The matter be mentioned thereafter. The file be sent to the department to enable the learned advocates to obtain certified copies of the relevant orders and documents.
Much appreciated, Lordship.
correction.
There are 6 beyond examination as EWS.
Yes, call the next.
Lord, I beg to appear for the petition, my lord.
Yes, some correction is to be
Yes,
made.
my lord. Yes, my lord. Para 6 of the order, my lord.
Let me see.
My lord, on para 6, my lord, your lordship had permitted the petitioners to appear in the examination provisionally. Your lordship had not mentioned that as EWS candidate, my lord.
My lord, subject to correction, perhaps that is not required. Let them appear provisionally.
My lord, otherwise,
There
my
is no
lord.
difficulty if they are appearing provisionally. Finally, my lord, it will all depend on the result of the writ petition. So
Okay,
whether
no,
as
but if
EWS or otherwise,
whatever, just you appear, whatever
No, my
is
lord,
there,
now the thing
whatever
is
you have
that-
applied, you have as per the same
No,
status.
my lord, now the thing is that if the admit card is issued in my favor as a general candidate, that will prejudice my rights, my lord. That's why that requires to be mentioned, my lord, as EWS. Only a single word, my lord.
that, my lord, perhaps is not a clerical mistake that can be corrected by, my lord, in this manner.
Your lordship had made the specific submission, my lord.
That is
My lord, I had applied.
Right as EWS.
Yes, my lord. Yes, my lord.
Yes, record an order. The matter is learned advocates for the parties are present. The matter is put up for necessary rectification. In paragraph 6 of the order, the writ petitioner was permitted to appear in the examination provisionally, but the candidate, but the specification with regard to the candidature was not mentioned. Thus, it is clarified that the petitioner is provisionally permitted to appear in the examination as EWS.
Yes, my lord.
EWS candidate which he applied for. Now, which he applied as under. হ্যাঁ তাতে কি হবে তার সঙ্গে গ্রেটফুল
Dada. 21. We are for the respondent, Milord.
21 you are for?
Our name has not been recorded, Milord.
Okay.
For the state,
Yes, record an order.
our senior name was recorded, but our name, Taposh Kumar Das and Rashtrikur Basu.
Learned advocate, this matter is put up for necessary rectification. It is submitted by the Mr. Bose, Mr. Rajshekhar Bose, learned advocate for the state, that the name was not recorded by mistake in order dated 31/12/2025. Let the name be recorded.
Taposh Kumar Das and Rashtrikur Basu.
No, it is written here only Mr. Vivekananda.
Vivekananda Bose.
So let the name of Mr. Rajshekhar Basu and Taposh Kumar Das be recorded in the order dated 31/12/2025. Other contents of the order remain unaltered.
Grateful.
Grateful.
22 Lordship.
Yes, it is for correction.
For correction, kindly come to paragraph 2. That is Purbo Bardhaman. It should be my Paschim Bardhaman.
You are for?
I am petitioner.
But I am for the state. You are for the state.
Yes. Purbo, it should be recorded Paschim.
Which paragraph?
Paragraph 2 and paragraph, my lord, 5.
Yes, record an order. Yes. Learned advocates for the parties are present. The matter is put up for necessary rectification of order dated 31/12/2025. In order dated 31/12/2025, in paragraph number 2 and 5, it is by mistake recorded as District Magistrate Purbo Bardhaman, which ought to be District Magistrate Paschim Bardhaman. Let necessary rectification be made. Stop. Other contents of order dated 31/12/2025 remain unaltered.
Grateful to you.
Opposite party, my lord. My lord, I am suffering the order of stay, my lord.
After to be mentioned, the fixed matter is recorded.
Please, my lord.
Just a minute, just a minute. Yes, 23. Assigned matters are usually taken up on Fridays. Part and assigned matters.
It is as per your lordship's direction on 12th January.
Okay, let it appear on Friday. You serve notice. Yes, record an order. Anyway, if repeatedly if a party does not appear, I have to hard in his absence.
Several times they are not bothered to extend the matter. 3-4 times later on, they are coming with an application for reimposition of the order of stay. In this way, my lord, the lower court, when the lower court taken up the matter, then they are saying that matter is pending, matter is stay. Well, it is a refusal of ad interim order of injunction.
Well, petitioner Mr. Anupam Bhattacharya is coming on, right? Just him.
Anyway, I am keeping it on Friday, but there should be no fail on that day. Yes, record an order.
Right.
Learned advocate for the opposite party is present. আমি ইয়ে দিয়ে দিন শুক্রবার রেখে দিচ্ছি না দিয়ে দিন নইলে পরে let this matter appear on 9/1/2026 within first 10 matters. Okay, call the fixed matters, 10:30 matters. Okay, application টা ডেকে দিন 25, yes.
Well, I am for the appellant petitioner, Malad. There's a application for delay of 53 days, Malad. That is can 2 and can 1 is for stay, Malad.
Have you served the condonation application?
Yes, Mr. Ali Imam Shah is appearing. Malad, he has already filed a court, Malad. I have served upon him.
Yes, record an order. এই ক্যান অ্যাপ্লিকেশনটা দিন তো একটু
Can 2 for condonation of delay. Can 1 is stay.
Yes, record an order. Learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. But have you filed your affidavit of service?
He appeared before, thereafter I served him. He appeared before.
Okay.
He filed a court. He already filed a court.
None appears for the respondent number 1. This application for condonation of delay is taken up for consideration. Hard learned advocate for the appellant peruse the petition file. Upon perusing the petition, this court is of the view that sufficient ground is shown for condonation of delay. Thus, delay in filing this application is condoned. Can 2 of 2025 stands allowed and disposed. Yes, what is the other application for stay?
Can 1, my lord. That is for stay.
Can 1?
My lord.
Yes. Have you deposited?
No, my lord. Since it was not formally
No,
admitted.
no. Statutory amount.
That has already been deposited.
Where is that document?
My lord, probably photocopy has already been in the record, my lord. This is a challan.
There.
A photocopy is
Just a minute.
Record a photocopy to them.
Yes. Record an order. Learned advocate for the delay. The Can 1 of 2025, which is an application for stay, is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 28th January 2025, passed by learned additional district judge, First Court Purbo Bardhaman in MSC 90 of 2016 for a period of 5 weeks. Stop. The appellant insurance company is directed to deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount within this period of 5 weeks. Stop. In the event the entire awarded sum is deposited within the period of 5 weeks, the ad interim order of injunction shall continue till disposal of this stay application. Liberty to mention.
Let it appear along with court 95 of 25.
Let this matter appear along with court 95 of 2025.
Grateful, may I take back the challan?
Yes, and give a photocopy.
That is already there. On the earlier.
You see, if it is not there, you supply a copy. Yes, call the fixed matter 10:30.
Challan
My lord, fixed matter. Mrs. Paul is for the appellant. My lord, she is not well fitted.
Okay. Then let me take the other matters.
Then tomorrow 10:30.
Yes, tomorrow.
Tomorrow 10:30. It is fixed as 10:30. Today it is fixed as.
Under the same heading, it will remain in the list as 10:30.
আচ্ছা এটা কি উপরের দিকে আছে তো
Item number 26, Your Lordship, I beg to appear for the appellant petitioner. On the last occasion, that is 25/11/2025, Your Lordship was pleased to grant the petitioner liberty to make a necessary application, which has been filed by us, and it is listed before the courtroom number 21 as can number 4 of 2025 in connection with SAT 356 of 2017, Your Lordship. However, that
whose application is this? Can 1? Can 1 is for what? Condonation of delay?
Your Lordship.
Okay. So copy has been served upon you. You are for the respondent.
No, Your Lordship, I'm for the appellant.
So this is your application.
Yes, Your Lordship.
You are for the respondent. Have you received a copy of this scan application?
Lordship.
How many days delay? So this has to be considered today. This application is to be taken up today.
Yes, Your Lordship. Lordship, today I'm actually praying for time because the can number 4 of 2025 in courtroom number 21 is yet to be heard. The
10-4
necessary,
is for what purpose?
the
sir?
necessary application that we had to take out, Your Lordship.
There is a delay of 6 years.
Yes, Your Lordship. There have been 2 appeals in connection with the same order, Your Lordship.
No, question is the matter appearing before some other court? That
Yes, Your Lordship, in court number 21.
okay, then let it be adjourned for this week. You mentioned that matter.
Could it be?
Let it be not this week.
Could it be 4 weeks, Your Lordship? Because the matter is yet to be taken.
So let the matter go out of the list with liberty to mention. Yes. Learned advocates for the parties are present. Let this matter go out of the list to enable the parties to take necessary steps with liberty to mention.
Item 68, my lord, deny pre-warning intelligence. My lord, the hearing starts from 34. My matter is 68. And let it be upgraded so that tomorrow it may be taken up.
No, that indication will be given 10:30.
10:30.
Yes, for today, but tomorrow?
No, tomorrow same.
For tomorrow.
Same
It will retain its position.
10:30.
Grateful,
Kalko
my
thak.
lord. Grateful, my lord.
I'm grateful.
27, my lord, I am for the respondent.
Mr. Pinaki Das is there. Mr. Pinaki
That matter, my lord,
Das
had
is there.
2,200 something days
There are
delay.
substitution application also.
But my lord, your lordship's pleasure was that so far as regards the other, my lord, no, not substitution, my lord, those, my lord, the application for, my lord, dispensation of service, your lordship
That
is
has to
of
be
the view
considered.
that that has to
No,
be
no, any
considered.
order has been passed on that.
Yes, my lord, your lordship, on the other occasion, the coordinate bench of your lordship's court already directed for some of the, my lord, respondents, the service of notice of appeal is being dispensed with. So far as regards the rest is concerned, your lordship is
Anyway,
of the
shall I pass it over and make it not today?
then, my lord, make it not today. My
Okay,
lord,
not
otherwise-
today.
Yeah, no,
Yes.
My lord, my senior is suffering from a physical illness. So give me a short date
What do you want? Not today or not this week?
next week.
Okay, not this week.
But sir, but my lord, I submit the affidavit in service today.
On the next day. I'm just adjourning it. Submit it on the next day.
Okay. Sir, make a short Passover.
Okay, short Passover. Okay, not today.
Pradhan for the appellant, my lord. The side is not here, make it not today.
Not today.
My lord,
33.
paper book has been completed, my lord, but a small issue is
So
there.
these applications are there, can 2 and can 3.
My lord.
Well, I am there.
No.
No, appeal is ready for hearing.
My lord.
Now,
Lord.
what is this? So, if it is ready for hearing, let it appear or let it be taken up.
My lord. My lord, only one thing, my lord, while going through the paper book, my lord, I find, my lord, a supplementary paper book is required for.
You are for the appellant?
I am for the appellant, my lord.
You are for?
I'm.
For the Union of India Railway Authority, my lord.
You are for?
We are on the same side, my lord.
And there are private respondents who should appear, my lord.
The plaintiff,
Okay, they have been served.
they have been served
They have
for
appeared.
several
They
occasions.
have entered appearance also.
My lord, my lord. They appear for several times.
If your lordship goes to the order sheet, my lord, they appear.
So, question is, the appeal is to be heard out. Let me fix a date for hearing
My
the
lord,
appeal.
my lord, we will intimate them, my lord. And another, we will sought for liberty, my lord, for filing a supplementary paper also.
Yes, record an order.
My lord.
My lord.
Learned advocates for the parties are present. Leave is sought for by learned advocate for the appellant to file a supplementary paper books.
My lord.
Such leave is granted. Let the supplementary paper books be filed on or before 19/1/2026. Let this matter appear on 19/1
As your lordship.
19/1/2026 at 3 p.m. as specially fixed matter.
My lord, liberty I will seek for my lord to serve the intimate the non-appearing respondent also.
Yes, the respondents be intimated by notice along with service of the paper books.
Grateful to lordship. স্যার দাদার নাম লিখতে হবে, এটা না এটা না লিখে দাদা লিখে দেবে।
Yes, 35 okay, not today. Thirty-six not today. Okay, 36 I'm making it not today. Yes, 35.
We are ready, my lord. My lord, judgment starts from page 138. Very long judgment, my lord. I am not, my lord, wasting time, judicial time, my lord.
No, you are the claimant appellant.
Appellant.
Okay, what is the ground of appeal?
38. My lord, kindly come to straightway, kindly come to page 157. 156. 156, internal page 18. 156. 156. Well, last paragraph. Hence, in the given case, before this tribunal, there was no impediment to determine such income of the victim, basing upon admission of owner himself, and accordingly, it is held that at the time of accident, victim would earn rupees 1,52,000 per annum, and here 1/3 income, such and such. I am not. Then, my lord, quantum no dispute, and page 158. 158. 158, my lord, 1, 2, 3, 4, 5 line from my lord below. Since in respect of third party insurer, taking premium only for such sort of breach cannot deny liability in toto, and hence direction for pay and recovery were given. But in other case, where insurer has not at all undertaken any liability, insurer cannot be sustained such sort of liability to pay, then to recover. Hence, tribunal is not inclined to give such sort of direction. So, tribunal directed the owner to pay the compensation. My lord, I am, my lord, relying upon Honorable Supreme Court judgment as well as this court judgment that pay and recovery. Only this part. My lord, income, quantum, no, my lord, dispute. I am on that, my lord, only pay and recovery portion. And for that reason, I am relying upon three judgment, my lord, pay and recovery. 2004-2 SCC, page 1, National Insurance Company Limited versus Baljit Kaur.
Yes.
My lord, first, my lord, paragraph 4, fact, The claim tribunal, relying upon the decision of this court in New and Satpal Singh, accepted the claim petition, such and such. Then, my lord, kindly
Paragraph
come to
4.
paragraph 4, fact, my lord. (20 and 21). It is therefore manifest that, in spite of the amendment of 1994, the effect of the provision contained in section 147 with respect to persons other than the owner of the goods or his authorized representative remains the same, although the owner of the goods or his authorized representative would now be covered by the policy of insurance in respect of a goods vehicle. It was not the intention of the legislature to provide for the liability of the insurer with respect to passengers, especially gratuitous passengers, who were neither contemplated at the time the contract of insurance was entered into, nor was any premium paid to the extent of the benefit of insurance to such category of people. The upshot of the above-mentioned discussion is that instead and in place of the insurer, the owner of the vehicle shall be liable to satisfy the decree. The question, however, would be as to whether, keeping in view the fact that the law was not clear, so long such a direction would be fair and equitable. We do not think so. We therefore clarify the legal position which shall have prospective effect. Tribunal, as also the High Court, has proceeded in terms of the decision of this court in Satpal Singh. The said decision has been overruled only in Asarani. We therefore of the opinion that the interest of justice will be subserved if the appellant hearing is directed to satisfy the awarded amount in favor of the claimant, if not already satisfied, and recover the same from the owner of the vehicle. For the purpose of such recovery, it would not be necessary for the insurer to file a separate suit, but it may initiate a proceeding before the executing court as if the dispute between the insurer and the owner was the subject matter of determination before the tribunal, and issue is decided against the owner and in favor of the insurer. We have issued the above-mentioned direction having regard to the scope and purport of section 168 of the Motor Vehicles Act 1988, in terms whereof it is not only entitled to determine the amount of claim as put forth by the claimant for recovery thereof from the insurer, owner or driver of the vehicle jointly or severally, but also the dispute between the insurer on the one hand and the owner or driver of the vehicle involved in the accident in as much as can be resolved by the tribunal in such a proceeding. That is, my lord, 2004. To SCC page 1. Thereafter, my lord, 2018 8 SCC page 492. Rani and others versus National Insurance Company Limited.
Actually, the owner of the vehicle has not come up against this order.
No, my lord. Rani. Paragraph 6. Paragraph, my lord, 16 and 17. Reverting to the appeal preparing by respondent number 1, insurance company against Anand, as noted in para 11 to 12 of the impugned judgment reproduced above. The High Court disposed of the said appeal by absolving the insurer from the liability to pay compensation amount. As noticed earlier, the appellant did not file any appeal against the award passed by the tribunal for enhancement of compensation amount, and the cross objection filed by him in the appeal filed by the insurance company came to be dismissed for non-prosecution. Even in support of this appeal, the tribunal has found that he failed to produce any evidence regarding the monthly income such and such. And 17, in view of the above, appeal are partly allowed by directing respondent number 1 to first pay the compensation amount to the respective claimant as determined by the High Court and tribunal as the case may be, and with liberty to recover the same from the owner of the offending vehicle. (2089)
এখানে দেখতে পাচ্ছিলাম আমি এখান থেকে বলবো
Another judgment, my lord, 2018-9 SCC 650, Samanna. গেল কোথায় গেলে 2018-9 মানে কিন্তু কথাতে ভুলে গেছি short judgment, my lord. Paragraph, paragraph 13, 14, 15. তোমাকে এখানে দিয়ে দিচ্ছি, ট্যাবে দিয়ে দিচ্ছি। Samanna, my lord, this judgment, my lord, Justice Gogoi and Justice, paragraph, paragraph 13. Since the reference to the larger bench in Parvanti case has been disposed of by keeping the question of law open to be decided in an appropriate case. Presently, the decision in Sarwan Singh case followed in Lokkinarayan Dhut and other cases hold the field. Sarwan Singh with me, my lord, the award passed by the tribunal directing the insurance company to pay, recover the same from the owner of the vehicle in question is in accordance with the judgment passed by this court in Sarwan Singh and Lokkinarayan Dhut cases. While so, in our view, the High Court ought not to have interfered with the award passed by the tribunal directing the first respondent to pay and recover from the owner of the vehicle. The impugned judgment of the High Court exonerating the insurance company from its liability and directing the claimant to recover the compensation from the owner of the vehicle is set aside and the award passed by the tribunal is restored. And my lord, in all the judgment, my lord, the parent judgment, so far my understanding, my lord, Saran Singh, National Insurance Company Limited versus Saran Singh, 2004-3 SCC 297. My lord, that judgment, my lord.
Yes.
If your lordship allow me, if your lordship kindly know.
Saran Singh.
My lord.
Okay, give the citation.
এটা দিন না 2004-3 SCC 297. The long judgment was 762 pages judgment. Lordship kindly have a look into.
Yes, yes, yes.
Three judge bench's judgment. My lord.
Yes, this judgment is frequently relied upon. Okay.
Then my lord.
Yes.
Lord, this entire appeal is confined only to the point, Lord, whether the right to recover can be granted, to the insurance company, once it is directed to make payment, in case where the owner has been directed to make payment by the trial court. Lord, your lordship asked one particular question, Lord, that the owner of the vehicle is not here. The person
Owner of the vehicle has not challenged this.
Yeah, the person against whom the order has been passed. Lord, on principle, Lord, I do not dispute this right to recover issue. And Lord, with regard to the answer to that owner, Lord, this Samanna judgment, which has been placed before your lordship, Lord, the third judgment was placed by
Samanna.
Samanna. Lord, in the Samanna also, your lordship will kindly take note, Lord, in the High Court, the claimant came up before the High Court. The right to recovery was granted. Claimant came up before the High Court. Insurance company also filed a separate appeal. Lord, the High Court said that this pay and recovery right cannot be granted. It is only under Article 142. Only Supreme Court has the right. So, my lord, the owner was also not there in the Samanna case as well, with the right to recovery pass. What my lord had posed the question.
So that was also by the claimant.
My lord, yes, that was also by the claimant, as well as insurance company also.
Yes.
The owner was not there. The Supreme Court there also, my lord, reaffirmed that there's no right to recovery can be granted. Insurance company, in spite of
It's not merely under Article 142.
Yes, my lord. But Supreme Court affirmed that no, High Courts can also grant, my lord, and there also the right to pay and recover was granted, my lord. Insurance company was to make payment and then to recover the compensation amount from the owner of the offending vehicle. So the presence of the owner, or whether the owner had himself or itself come up before the court against the impugned award or not, my lord, that becomes immaterial in view of the larger principle. Because, my lord, the claimants are not supposed to be deprived. That is the principle. Your lordship is right from the day one is only on this principle. Whether the question is whether insurer would pay or whether the owner would pay.
No, earlier that principle was followed that it is the one under Article 142.
Lordship. In certain cases it was.
But here also the claimant has not come.
Yes, the owner has not come.
Sorry, claimant has come, the vehicle owner has not come.
Lordship. But in these cases also, my lord is of the view that no, the claimants are entitled to get compensation, then insurance company to pay and recover the money from the owner of the vehicle. My lord, that principle, my lord, remains. My lord, that is there, my lord. And since that is the only issue, my lord, I wouldn't be, my lord, arguing further and wasting a lot of time on this. But without recording my concession and on the basis of this judgment, my lordship, only, my lord, this reverse this particular finding, my lord, that in the facts of
because still today this law,
my lord, as an aberration. Because, my lord, when I've got 1,000 or 2,000 judgments of Supreme Court which say that no, we principally hold insurance companies not liable, but still, in order